Hello, Brenda.
You want to see how nervous I am?
Yeah.
I wrote notes.
I'm feeling better. I've been planning all day to use my personal computer, and then at the last minute it starts like messing up, and the video, like I was trying to play the video that Chris put together and it's like shaking all over the place. So I had to change my plans to use my work computer, and I'm glad that I'm not going to be talking much, because the reason I usually use my personal computer for Zoom computer, like it cuts in and out. So hi, John. Brenda, do you know John? He works at my office. You don't need to know him.
Hi, John.
Hi, Brenda. Hi, Mary.
Hi.
She's so lovely, isn't she?
He's so kind.
We like to say small doses. I'm going to show you something.
Okay.
Mary is the one you want to get Secret Santa.
Oh, yeah. What did you get him?
So
I'm having a bad day. I just reach in the basket. I pull something out.
So with the legal project, we fill out these little lists for our secret snowflake, and like it's like, what's your favorite this and what's your favorite that? And so he put like, you know, I would like I really can't remember, like a Corvette or something. So I got him a Hot Wheels Corvette. He was like, I would like relaxation time, and so I got him. Oh, he said no more kids, so I got him that little ball.
I did not appreciate this gift. Hi, Sarah. We're showing off pictures of our children.
Is
that Sydney or
Sarah? It will surprise you none to know that when I got John the Secret Santa, I got him a bunch of rude little gifts, such as that doll, because he said he wanted no more children. So I got him that little doll. He said he wanted a Corvette, so I got him a Hot Wheels Corvette.
what is her name, John?
Yes, it also had beer, which is long gone.
Oh yeah, wow.
Which is the one part she got right.
Hey, I don't know how to add co-host.
Lisa Ravage just got on and she can do it.
Nice.
Okay, what are you having me do?
Adding, right now it's just me and Brenda that need to be added as co-host. And then when Trevor, Lee, and Mark get on, they will need to be added as well.
Alrighty, let's see.
I even put on a suit jacket.
I like your shirt.
Look it up.
Now, why can I not make you a co-host?
Hi, Lee. Let's see, I know for me, it's when you go like to participants and you see my name, you click on the more button, and then I think you can add as co-host.
All right, let's see. It's not letting me do that.
That is not good.
No, it's not, because I...
Now, how do we need to? I added you, Sarah, so you're good. I'm a co-host. I should be able to add you. This is not right. Who else needed to be added as a co-host? Let's see if I can do that.
Brenda.
Okay,
Trevor,
let's try.
Brenda.
Let's see if I can get.
Even if we can just get Mary, that would be great.
Yeah, because I'm supposed to be sharing my screen for half the time.
Yeah.
Well, this is insane. I don't know why.
Sarah, as the main co-host, can you do it? Like if you go to the participants button And then any of us who you want to be a host, click on the more button beside us.
Let's see. Brenda,
I
I've got you. Mary. I've got,
Oh, Brenda's a co-host now.
Yay.
Yay.
Oh, look, it says that I'm a co-host too.
I just did it.
Oh, okay. Now, why wouldn't it let me? That didn't even come up as an option. Love technology.
I'll add Lee just for fun.
Lee, it just means that we can't control you anymore. That's really what a co-host is. We can mute and take everybody else's videos off, but we can't do that to you. So
Lee can't be controlled. What do you mean?
Everybody's going to be joining us soon, and because this is not a webinar, so everything can be heard and seen. So
we can click mute all though, which I think right before the CLE starts, I'll click mute all, and then the presenters will have to unmute themselves.
Unmute themselves. Yeah, that'll work. And I have the program automatically recording, so.
Oh, great. I was going to ask about that. Is everybody okay with us recording this? Cool. I will ask Mark when he gets on, but I think he should be fine.
You know, I'll make a general announcement at the beginning that it's being recorded too, just for in the interest of transparency for those putting questions in the chat, because they will want to know that.
And Mary, will you be announcing the code words at some point during the session? The two of them we decided on? Good.
Yeah.
Is
Sarah,
it 2 or 4?
2.
It's just 2.
One
Okay.
for each hour.
Okay.
I said 4 at first, but I was wrong.
Mary, can you resend me the order of presenters so that I can make sure I do it correctly?
Yep.
It needs to just be at the top of my email.
I'm going to put where I'm going to say the code words in there just so you know when I'm
Okay.
Mary, I'm just gonna step away for a second.
Yeah, I'm gonna go get a notepad because you guys don't need me for another couple minutes.
Brenda, I don't see Mark on yet. Will you call him and text him? Thank you. And Lisa, can you make Trevor Hannigan a co-host as well? I tried and it wouldn't let me. It might not let you, but I just thought we'd try.
I went ahead and did it. Sorry about that, Trevor.
It doesn't even give me the option, which is odd.
Yeah, it might just be Sarah as the main host because it's not giving. I could have sworn that last time I did this, that Zoom has changed.
Oh, you know what? Yes, that's true. Yes, it is. That's why.
That's all right. I think he's in now.
Okay.
I am so sorry. There are two separate links that went out for this meeting. So I think there was another planning meeting for another CLE and that link went out as well.
You're good, Chris.
Sarah, can you make Mark a co-host as well?
Yeah, Chris, thank you. I also went to the wrong meeting. I couldn't quite understand what was going on. They were talking about something else. So there may be others who, like me, don't understand how to do this. Maybe if there can be Mary or someone could just send out the new Zoom link again as a reminder to people.
Yeah, Lisa, would you mind doing that?
Me?
No, Lisa.
Yeah, Lisa.
If they had, I did send it out again. If they'd opened up the second email, it had it right on there.
Okay.
Just it's a Zoom link and had the password there for everybody.
Yeah. Maybe other people are smarter than me, but I didn't understand what that meant. Thank you though. Thank you, Lisa.
No problem.
And Mark, I'm making you a co-host, just in case.
What does that mean?
You have all the power. You can help mute people, whatever we need to
Really?
do. Manage participants.
I can mute Trevor Hannigan if I wanted to.
If you really wanted to.
I think I was muted, Mark.
All right, should we start to keep on schedule?
Let's do it.
And make sure our CLE folks can get their CLE credits. All right, welcome everybody. Folks are going to be trickling in over the next couple of minutes, but I wanted to welcome everyone. I'm Professor Sarah Rogerson at Albany Law School. I am not the lead organizer of this event, but I've been asked to kick things off and say a few words. So welcome and thanks to all of the groups who did organize this event. They're all on the flyer. It was really impressive, fast gathering, and they should all be commended. Note that we have participants who are lawyers and those who are not lawyers, but the lawyers should follow the instructions that you were given in order to get CLE credit. There are 2 forms that need to be filled out, and we'll be giving you code words, 2 of them, through the presentation. Mary Armistead will chime in with those. She's also going to be functioning as timekeeper. So if you think that there is some rude woman interrupting the speakers, that was planned. So that's how we will manage each other. In terms of other housekeeping, we know that you will have questions. Mary is also going to be monitoring the chat. Some of us who are on the panel but who are not speaking will also be looking at chat. If we can answer your question in the chat, we will. If it needs to be answered in the presentation, Mary will facilitate that. And if it can be answered at the end, we will have some time at the end to filter through conversation today. and it might actually answer some questions preemptively that some of you may be asking. And I just wanted to talk a little bit about my observations about the attorney role for that particular movement. It may not speak to this movement, but there are some good takeaways, I think. There's obviously a difference between legal observers and direct representation of protesters. Those are two different functions. Some of you in this room have been to the NLG trainings. I see Nick Rangel is a participant. Nick, shout out for the quick movement on getting the NLG trainings together. And I believe I saw that one is actually recorded. So be sure to go to the Facebook page for the Albany chapter of the National Lawyers Guild. We won't be speaking as much to legal observing because we're going to be talking about that second role, representing the protesters after the action. And so one of the biggest things that when I was preparing for today was to think about was that you want to avoid becoming a fact witness. As a lawyer, you have a particular role. And so you want to avoid being in places or being in conversations where you're learning information that would expose you to becoming a fact witness later on and might preclude you from representing folks later on. So as a centering thought, I'm actually going to ask all of us to decenter ourselves in the movement and our role as lawyers in the movement. The movement is happening, and we are here to support in a lawyer role. We're not there to provide critique or opinion about tactics. It's best not to know many of them if you plan to represent protesters after the action. And it's better to be available for consultation to the movement in terms of planning in order to give them a sense of potential legal consequences for various actions. And that was primarily the role that Mark and I played, those two roles for the Poor People's Campaign. So those are my grounding principles and some takeaways from my recent movement lawyering experience. But you're not here to hear from me. You're here to hear from Chris, who will kick it off. Chris is a 2021 prospective Albany Law grad, and we're so glad to be starting our presentation with her reflections on the current movement and her participation. Chris, go for it.
Hello, everyone. Thank you for showing up today. So I know right now you're seeing videos of the protests. I kind of had to reach out to some of us that were there. I want to say we were there on a Monday, and I remember because it's the Monday before my birthday. But what ended up happening is we went fairly late in the day. The protests had been going on from 10 a.m. to roughly 9:45, 10:15. The window there gets a little foggy for me. And what you can see is that by the time we arrived, the protesters were largely peaceful. And yeah, there was some yelling and screaming back, as happens at a protest. But I think what stood out to me the most was the fact that Albany Police Department showed up in paramilitary gear. There were snipers on the roof. We saw them behind the blockade. When we walked around the street, because we could see them, like the video's not showing here, but like one of the original videos that I had shot was you could kind of see them inching towards us from around the police station. This is the one right there on 2nd Ave, like right off of Henry Johnson. You could see them inching around the building. And so like we kind of wanted to know where they were coming from. Little did we know we were gonna come around the corner to this. Even though they were there, the protesters largely tried to remain peaceful, but around 9 p.m. is when we started to see the change happen. I think what stood out to me, like there was one particular moment, and I'm so heartbroken that I didn't catch it on camera, that the protesters were asking, they were chanting, take a knee, take a knee, take a knee. And the officers did take a knee, but only to put on their gas mask. And at that moment, I knew like there's a possibility that you won't make it home tonight. Because at that point, they had tried to appease the crowd by sending out the minority officers to come speak to us. And we're like, as protesters, we're like, this is not you guys' problem. We want to speak to the people that are the problem. They refused. I remember one of the sergeants saying he didn't want to speak to us because we were violent, because we were screaming. Around 9:45, there was a young man in the crowd with us who had gotten into some sort of tussle between him and the representative that was there. The crowd, immediately realizing what was going on, turned to kind of get that under control, was like, hey, this is not what we came here for, this is not what we're doing. And unfortunately, and I'm going to phrase it as honestly as I can, the agitator in the crowd didn't look like me. It wasn't a Black person. It wasn't a person that was a part of the Black Lives Matter movement. They set off a firecracker, and I was standing there with one of my classmates, and it took about 10 or 15 seconds for us to really figure out what was going on. We heard the two pops. The first one through the crowd went to the building where the top of the building where the snipers were. The second one went across the fence. And so we took off. And by the time I turned back around, I couldn't see the street. Like, it was all white. And it was only one protester. And I think what's even more scary is, like, as we were running down the street, we took off down the street at the speed of light. We're running. The second brigade of officers that they had put behind, not the police department, but the building that was on the other side of the street, they put a second brigade there. And literally, as they were trying to reach to grab us, we kind of like turned around and moved. But you see the dogs, you saw like the tank that were there, you saw the officers dressed in their paramilitary gear. And all I could think is it was one person in the crowd. I was speaking to officers afterwards, and I remember asking them, like, why is this the appropriate response to a peaceful protest? And the officer legitimately, his response to me was, well, what else were they supposed to do? How are we supposed to know who's there to agitate and who's there as a protester? But for those of us that were on the ground, you could tell very clearly, like, the agitators came prepared to agitate. They had their gas masks, they had their goggles. So it was just a matter of, you know, one, I had the feeling that Albany Police Department really wanted it to go a certain way. When you show up and already geared out snipers on the roof with your paramilitary gear, you're sending a very clear message to the crowd. But two, even the officers could acknowledge that they knew what the agitators looked like. So even if they weren't going to start the confrontation, it was going to be allowed to happen, because the response was there was 2 canisters of tear gas that was let off into a crowd of people. I know there were representatives from Albany that were in that crowd. There were attorneys who worked with the court who were in that crowd. Like, everyone was trying to largely remain peaceful. And I think, like, after this protest, I got on social media and told my classmates, the one message that came very clear after this protest was that our role isn't on the front lines. Like, we're just another body that's there, versus, you know, using our intelligence and using our degrees to really, there goes the video now, like, we couldn't see the block, but, you know, using the resources that we have to help these people, because the reality of the situation is, this is what it means for them to protest. I think when we think of a peaceful protest, like, we're not realizing that police officers can be agitators too. And that's kind of really what I have to say about the protests.
Thank you very much, Chris. So next we have Brenda Badam, class of 2017, formerly with the Albany Prosecutor's Office and now an associate at Barclay Damon. Brenda, take it away.
Thank you. Hola, everyone. I was a former ADA with Albany County. I spent 2 years there. I was able to prosecute most lower level offenses, and that includes the charges that came from previous protests, where I remember seeing Mark and Professor Rogerson in court. I am a little nervous. My first language isn't English. So if you see me use my hands or stop suddenly, please don't be alarmed. I'm not having an attack. I really am just nervous. Mary, if we can go on to the second page, please. A disclaimer from my office. This is just for informational purposes. It will give you some tips and tricks, but it shouldn't be considered legal advice. Mary, if we can move on to the second one. Okay. So, George Floyd was born in 1973 in North Carolina. He was murdered by Officer Derek Chauvin on May 25th. His last words were, "I can't breathe." The reason why was because he was being arrested for a forged check. Brianna Taylor, on March 13th, the Louisville Metro PD attempted to serve a no-knock warrant related to drug trafficking investigation to her home. A shootout ensued between Ms. Taylor's boyfriend and the police. She was caught in the crossfire and she was shot multiple times. She would have been 27 on June 6th. Mary, if we could go on to the next slide. So both these names have been fixtures in recent protests spurred by their slayings. Here you'll see Ahmaud Arbery, who was just running and was caught between former police officers while his running was going on. That has then led to an uprising in movement lawyering. So movement lawyering, as you see, is the practice of representing vulnerable populations in an effort to support social movements and promote progressive policy. So movement lawyering, it's real, it's raw, it has an immediate impact on your community, and it allows us to see the way that the laws are moving, how they're alive, how they are being able to be lived on a daily basis, and it recognizes the power of change and also allows us to see the individuals, not just the collective, but the individuals. Mary, if we could go on to the next slide. So that being said, let's start from the beginning. So the right to protest is a protective right. So First Amendment allows you the freedom of speech. It allows you to say what you would like to say with some restrictions. And those restrictions are if you provoke violence or you incite a clear and present danger or lead to an illegal action. Now that gets tricky when it comes to protests because at any point, what does it mean to present a danger and who are you presenting a danger to? Is it to the officers or is it to other people? So it's very subjective and it's still, I think, up in the air, truthfully. May I please go on to the next slide, please? You also have the First Amendment right to assemble. The key words are the peaceful right to assemble. So you have the right to protest as long as it's peaceful. This allows you to express your views without the restrictions of government over your right to assemble, but again, it doesn't condone illegal actions. So now that we are all here for information on how to represent those who have been arrested for protesting, there are certain key principles and issues that you should be aware of prior to that representation. Mayor, if we could go out to the next slide. So one of the major things that we want to stress today are the Miranda Rights. So the Fifth Amendment allows you the right against self-incrimination. That doesn't mean that it only happens on the witness stand. It could be at any time, even when you are being questioned by law enforcement officers. So most of you hear the phrase, "I plead the Fifth." That doesn't only happen in court, it can happen before that. And it's critical that we get involved in that stage too. The Sixth Amendment right allows you the right to legal representation. This is where you come in. Now these principles were then merged in Miranda v. Arizona, which most of you should be aware of. But let me just give you some background. In 1966, Ernesto Miranda, which is the person pictured in the slides, was arrested for rape and kidnapping after the brother of the victim identified his vehicle. Once he was arrested, he participated in a lineup. That lineup then led to a discussion with the officers where he asked, "How did I do? Was it okay?" Sorry, my lights just keep coming on and off. I'm sorry, guys. After that conversation, the officers positively stated that he was positively identified. He then went to give a confession, a verbal confession. After he gave a confession, he spent 2 hours with those officers. He was escorted to where the victim was, and the victim identified him by his verbal speech. Then he came back to the precinct and gave a written confession. All of these things happening without him having an attorney, without him even having knowledge that he could have an attorney. The officers opined that because he had been in trouble prior to, multiple times before, he should know of that right. But not once would he read his rights. And so, Mary, if you can go on to the next slide, please. So this is where the Miranda warnings come from. So if any of you watch Law and Order, like I do, on a daily basis, you probably know these like the back of your hand. You have the right to remain silent. So important. So drilling into our clients, don't say anything. Anything that you do say can be used against you in the court of law, even if it's spontaneous, even if it's an off-the-cuff remark. You have the right to an attorney. And if you can't afford one, one can be afforded for you. One can be provided for you. And they finish off with, do you understand this? Mary, if you could go on to the next slide. So a common misconception that people have is that an arrest leads to a Miranda warning. An arrest can happen without Miranda warnings being given. They're not common, but you can have an arrest and never a warning being issued. They're only required to give a Miranda warning if two things happen. One, that person is in custody, and two, they're going to be questioned. So
I'm sorry, I'm gonna stop you just for a second. I am of confusion through my text messages about people maybe being on the wrong Zoom. I cannot see the chats right now until or maybe it's on the other Zoom link that people are in the chat. So I just want to try to figure out what's going on here. So let's see.
Excuse me if I could. We were on another Zoom link that was provided. Someone in the chat box did give us the link to come into this Zoom meeting. So there still may be some people on the other Zoom.
Okay. But on the other Zoom, it was put into the chat box, the correct one to come into.
Yeah, correct link was provided in the chat box because I was in the other Zoom.
Great.
Okay, I apologize. Can you send me in this chat the link to the other Zoom that you were on so that I can try to log on there and clear up any confusion for anyone still there?
Yeah, let me try and do that.
Actually, Lisa, would you mind handling that so Mary can keep flipping the PowerPoint?
Sure.
Okay, thanks, Lisa.
Yep.
All right, thank you all. Sorry, Brenda. I will let you get back. I apologize to anybody who missed our introduction because of the Zoom link confusion. This is recorded, and so you will be able to go back and look at those first few minutes that you missed of the recording. All right.
no worries, it gave me time to drink water. Okay, so for Miranda, right, the police are only required to give Mirandize someone when they are in custody and an interrogation is occurring. That means you can get arrested and no warnings be given. If they decide later after you are in custody that you want to give warnings, that the officers want to give warnings because they want to speak with you, they can. Mary, if we can go on to the next slide. Now, for protesters, this is important. This is extremely important because in a charged environment where there's an emotional outing and you have a lot of people just speaking, spontaneous statements can be made to officers during that arrest. Those spontaneous statements are fair game, even without Miranda warnings, because they're spontaneous. So it's something that we should be mindful of. It's important to speak to our clients prior to, or as soon as possible, really, for them to have a fresh recollection of what was said, what if any statements they might have spontaneously said, and what, if any, statements could be used against them. Now, once Miranda Rights, or once Miranda Warnings are given, the person in custody must give a clear affirmative answer to this question. So if they say silent, that is not an acceptable answer. So they can either say, yes, I will speak to you, to their law enforcement official, and they could waive their rights. And on the left-hand side, you will see a copy or a picture of what a waiver of rights looks like. It basically said, I have understood my rights, I'm willing to waive them, and I'm willing to speak to you. Or they can say, no, I do not want to speak to you. And then that interrogation is over, that questioning is over. Now, if the individual states that he wants to speak to law enforcement officials, he, at any point, really, can stop and wish to remain silent. They could stop the interrogation. They can also ask for their attorney to be present. At that point, when the individual says so unequivocally, then the questioning must stop. The officers must no longer ask any other questions, and they must get in contact with the attorney or go forward with the investigation without questioning. So the good thing is you can change your mind. The person being questioned could change their mind even if they start speaking. In Albany, I've seen that the detectives use waivers, such as the waiver of rights, in order to get people to speak to them. Now, when it comes to protests, you might not have a pen and a paper ready to waive those rights, but just keep that in mind that in Albany, usually they have a waiver of rights that they can use, and that you are, as an attorney, able to see that waiver of rights. Mary, if we can go on to the next slide. So, most important thing I can say is to recommend to clients, to protesters, to anyone that you know that could be potentially in danger of getting arrested, is to wait for an attorney to say anything. Remember that it is the job of the law enforcement officials to investigate. This is what they do for a living. So they will use those tactics in order to get the information that they need. As attorneys who are representing these individuals, we have to look for certain things. So one of the most common things that I'm aware of is video interrogations. So if there is any video that is taken at the scene or afterward, any notes taken by either law enforcement or detectives, body cameras that capture these interactions. And then once you get to that point, and I'm sure that Mark and Lee will speak about it more, but there are these things called 7-10-30 statement notices where they have to tell you when there was a statement made and give you notice within a certain amount of days of the case actually starting. So those are just some things to keep in the back of your mind that will help you when you are thinking about representing such individuals. Mary, if you could go on to the next slide, please. Okay, so when does the right to an attorney actually kick in? So we have the Sixth Amendment, right, which you spoke about before. The Supreme Court has held that you can waive the right to an attorney, knowingly and intelligently waive that right, or you can reap the benefit of that right, right? In order for the Sixth Amendment right to counsel to apply, it has to be a critical stage in a criminal proceeding. So a critical stage is any step during a criminal prosecution where the accused's rights may be affected by the absence of legal representation. That includes police-initiated questioning, okay? So if they are arrested during that time, they can ask for an attorney. If for protesters, if they're questioned, they are again entitled to an attorney to represent them while they are being questioned. Mary, if we could go on to the next slide. Now that right comes from a multitude of precedent of cases on which most of you either learned in law school or forgot in law school. But for example, so Powell v. Alabama, goes back to what is called the Scottsboro Boys. So there were 9 Black boys, young minority, seen as not as intelligent boys accused of a rape. All 9 of them went to trial. There were 3 separate trials. All the trials were done on one day. They were all convicted after a one-day trial, and they were all sentenced to death. So it was very quick, very fast. They were not given the time or the opportunity to get an attorney. The court has held that it is a denial of due process to not give a defendant the time or the opportunity to receive an attorney. We're really lucky that we are joined today by the National Lawyers Guild in the Capital Region. So they will be able to give more information about attorneys being, representation being offered specifically for protesters, but this is something that you should be aware of, that it is a right to have an attorney. If we go to Gideon, Gideon v. Wainwright, the defendant was charged with breaking and entering. He asked for an attorney. He was denied that right because at that time in 1963, that right was only given to capital cases. And so most felonies like breaking and entering did not receive that same right. The court then extended those rights to all felonies where an indigent defendant needed representation. And the same goes for Argersinger. I think I'm saying that right, but I don't know. So the court then extended those rights to misdemeanors or any crimes that the penalty could be taking away of someone's freedom. So Mary, if we can continue. So this is where it gets tricky. Escobedo, and I'm saying it in the Spanish connotation, it might be a different way, but Escobedo. So this was a case where the defendant was asked to talk to an attorney. That attorney was present at the station. The defendant asked multiple times. They were not allowed to speak. And because the officers couched it as a investigation instead of an interrogation. The court then held that the right to counsel comes when there is an interrogation, when the interactions shift from an investigatory nature to an accusatory nature, and then you have the right to consult with an attorney. Escobedo was then overruled by Miranda only on principle, but not on the actual facts of the case. So Miranda held that the interrogations violate the Fifth Amendment right and not Sixth Amendment rights. And we spoke about Miranda before. And lastly, Messiah was a narcotics offense case where there were co-conspirators and officers were asking co-conspirators to wear certain devices in order to work with the police. That conversation was surreptitiously, and then that was then used in his case. So the court then held that once an accusatory instrument is filed, so once a protester actually goes to court and a filing of either a misdemeanor complaint or a felony complaint is had with the court or they are indicted, the right to counsel attaches. If we can go on to the next slide, please. Now, it sounds like I'm talking about the same thing, Miranda versus Messiah, but there are differences in them. So Miranda talks about whether someone is in custody and the custody arises from an arrest or a physical restraint, and it does not prohibit undercover questioning. Messiah, on the other hand, applies either in or out of custody, and it attaches by that first criminal accusatory instrument, and it allows for passive listening but not active. If we can go on to the next slide. Okay, so this is really important. We're talking about search and seizures, the seizure of a person the interference of the freedom of movement. So when someone is actually arrested at a protest, and it could be by force or by the show of authority. This is a very subjective standard. It's a reasonable belief that you are not free to terminate the encounter at will. It doesn't have to be at a police station. You don't even have to be in a cop car. As long as you feel like you are not free to leave, you are seized. And these rights are articulated in the Fourth Amendment. And then when it comes to a search, once you are arrested or even prior to arrest, you could have a search done on you, especially at a very high energy, intense protest where they might believe that you have weapons on you. And it is a government intrusion upon your expectation of privacy. If we can go on to the next slide. Okay, so a seizure occurs when that person, when the defendant submits to the commands of an officer acting in the color of law, and someone is restrained by force or somehow otherwise, but there's facilitated submission. And then once that seizure occurs, so for example, in a protest, usually the arrest will happen by an officer in a high intensity area. At any point where you are not free to leave anymore, you are now being seized. So it's good to know when it actually occurred. Mary, can we move on to the next slide? Okay, Terry v. Ohio. Most people know about a Terry frisk or a Terry stop. This case set precedent for wide varieties of Fourth Amendment cases. Mr. Terry was with a friend in front of a building where two plainclothes officers approached them because they felt that they were casing a job, right? They looked suspicious. They stopped them, they frisked them to see if they had any weapons on them. They felt like there was a bulge that could have been a handgun. They patted them down for weapons on the outside of the clothing, and then subsequently, there was a conviction and he was sentenced to jail for 3 years. Now, the court held in Terry v. Ohio, it is a reasonable search for police officers to interrogate and frisk individuals without probable cause for an arrest, as long as the officer can articulate a reasonable basis for that stop and frisk. So reasonable basis. That case then set off a bomb of cases. But in New York, what's really important to know, and especially for cases where we're representing protesters, is they can be stopped, they can be frisked. Depending on that frisk is how the arrest happens. So those details, those intimate details prior to detainment are very important. It is essential to speak with your client regarding what occurred during that time period, and to lay out a set of facts that you can follow. Mary, if we can go on to the next slide. Okay, so in New York, there are 4 levels of police intrusion. Specifically, we follow DeBoer. At the time that a officer is arresting someone, they have probable cause that a person has committed that crime. That's already a level 4, right? But there's 3 other police interactions levels that we can have. So they can, they have a credible reason that something is about to happen, not just a whim, but a credible reason. They either received information or something of that sort, where they can approach you and request basic information, including for you to identify yourself in let's say, a protest setting. Level 2, an officer can ask you more specific questions, such as where you're from, what you're doing here, who did you come with, do you have a record, those kind of questions. If they have a reasonable suspicion that that criminal activity is afoot. What criminal activity is subjective and it's up to the officer, but just that there's a suspicion that something is happening. Level 3 can Officers can stop and detain you if they have a reasonable suspicion that there was a commission of a crime. So for example, a common misdemeanor that I know Lee will speak about is obstruction of governmental administration, right? That's a misdemeanor. You can be stopped and detained for the commission of that crime, and then search, have that whole interaction, arrested, just for obstructing governmental administration, right? So just keep those in mind, the levels of intrusion that police officers can partake in. Mary, next one. Okay. Now, once that individual is arrested, that the police officers may search the person incidental to arrest. So similar to those spontaneous statements or statements we talked about before, once you are arrested, you are searched. Anything in your person is fair game. So I urge people to be careful of what they have in their pockets. You would be surprised how many cases start off as, my license is suspended or something of the sort, or I'm parked in a fire hydrant or an open container in a car. And then once a search of the person is done, now you're charged with felonies for controlled substances, or you had crack cocaine on you or something of that sort. So be mindful and have your clients be mindful of what they keep in their pocket when they go out to these protests. Furthermore, something that should be known is at the time of arrest, most people that are at these events are recording now. It's very common to record. While you could have credible information on your phone that could help you, your phone may be confiscated. So one, you can ask your attorney to have that evidence released, and through the DA's office, it could be done. Or if they let you go, then you get your phone back and then you immediately save that information. So those are the kind of things to keep in mind. And Mary, if we can go on to the next slide. Now, with that being said, there is no burden of proof on a defendant. That burden of proof is always, always, always on the prosecutor's office. But as attorneys, there are things that we can do to make sure that we cover all our bases, that we are taking into consideration all facets of an interaction to help our client. Mary, next slide. So, for example, again, videos are so important. Snapchat, Facebook Live, all these videos, if you think that you can use them, they're public, and you can present them to the prosecutor's office to start open communication. But also, if the video helps you in the future, you can, if you are able to bring them in, you can use them at trial. So ask your client, are there videos of the incident? Do you know of anyone who's recording? What stations are around your area that can, first of all, videotape and we can use? Second, friends turned into potential witnesses. So look at friends that were in the area that can help you. If they saw what went down and they recorded it, that's even better. That's what happened in George Floyd. That's literally just a great piece of information. So keep your friends around, keep vigilant of to who is around, who can help. There's also business cameras in the area sometimes. So that might be a resource that you can look into. And a very big plug for the Lawyers Guild. So they wear the green hat, and they are trained to take notes and to observe. And usually there's a way to see who was in the area, who were the lawyers in the area, or who were the observers in the area. So keep in mind that can also be a resource. Next slide. All right, guys, if you have any questions, here is my information. You're more than welcome to reach out to me, and I will be more than happy to help you. Thank you.
Thank you, Brenda. Before Sarah, before you introduce our next speaker, I'm going to go ahead and give everybody our first CLE code, which is systemic. So all you lawyers who are seeking CLE credit, make sure to write down the code word systemic. This is one of 2 code words that you will need to include in the form. Systemic. Thank you. Go ahead, Sarah.
Great. Thank you, Brenda. And I just want to say it was a pleasure to see you in court. All right, next we have Lee Kinlan, who is of the Kinlan Law Firm, who is a seasoned criminal defense attorney. And Lee, why don't you take it away?
Thank you very much. Let me just say, it's nice to see everybody again. It's nice to see people again. I've been scrolling through the pages and looking at old friends, and I don't know, it's been a weird couple months. So one of my favorite places in the world to practice is local court. Most because that's where I started. And Lavonda, I know you're on here. When Lavonda way back in the day was a prosecutor and I was a defense attorney, and she used to take advantage of me every day because I didn't know what I was doing. Local criminal court practice, once you get the basics down, which is just what I want to talk to people about today, it can be a place where you can get a lot of stuff done. So I know my assignment was to talk to you about arraignment, bail, and common charges. I'm going to start at the end of the list and then work backwards towards arraignment and bail. Excuse me. Some of the most, and I'm not going to talk specifically about Albany. I'm going to talk about the generic local criminal court because in a very good way, these protests are going on everywhere. And I understand that all the little local courts, and I've asked around, all the little local courts have some little quirks, but I think generically, this is going to get you through just about anywhere you go. Common charges for these types of events, and I'll start small and I'll work upwards. We've got things like harassment in the second degree and disorderly conduct, loitering. Those are all what are called non-criminal violations. And I'm going to go over some stuff that everybody probably already knows, but non-criminal violations are not crimes. That is, even if you are convicted of disorderly conduct after a trial and the judge sentences you to the maximum possible punishment of 15 days in jail, you still do not have from that a criminal record. Harassment in the second degree is, in this context, probably just yelling threats and making somebody feel threatened. Loitering is the gathering of, you and a group of people. There actually is a subsection under the loitering statute that says if you and a group of people gather wearing masks, that can be considered loitering. Up from those 3 non-criminal violations, you have something called unlawful assembly, which is a B misdemeanor in New York. It is considered a crime. B misdemeanor is the smallest possible crime that you could be charged with. And if you're convicted, you could do jail time and you would have a criminal record if convicted of unlawful assembly. Up from there, we've got A misdemeanors like inciting a riot. And I know Brenda mentioned this during her talk, you've got 2 of the more standard things that are charged in something like this: resisting arrest and obstructing governmental administration. Now, I have seen, and I know my colleagues, you've all seen the charge, resisting arrest. And then you get down to the to wit portion, why are they accusing you of resisting arrest? And it's, they resisted arrest for being arrested or something like that. That is, there needs to be something for which you're actually being arrested and then you resist. And so you always want to, I mean, we'll get to that in arraignment, but you always want to look to see why they were arresting you. Resisting arrest and obstructing governmental administration are usually charged together. They're what I always like to call alternate theories of proof. That is basically kind of mostly they cover about 75% of the same alleged conduct. But there's enough of a difference that you could be charged with both. If you are eventually convicted of either one of these things, they're both A misdemeanors. And an A misdemeanor can carry with it up to a year in jail, local jail, or 3 years of probation or some combination thereof. Now, again, in today's environment, and Mark, who is one of the guys I see all the time doing stuff like this, and I really feel like we're all just warm-up acts for Mark and his war stories in a couple of minutes. When individuals are charged with some combination of, say, disorderly conduct, resisting arrest, and obstructing governmental administration, there's usually a way to litigate those cases because you've got a friendly prosecutor, you've got some jurisdictional defects in the charge or something like that, but I won't step on Mark's speech. Up from there, and I know recently in Albany, there's a young man charged with assault on a police officer. There are two different crimes. I mean, there are a bunch, but the two ones that you commonly see, assault in the second degree, 120.05, that's a D violent felony, assault in the second degree. That is when you assault a cop. And this is somewhat newer, but it's assault on a police officer, 120.08, which is actually a C felony. Now, D felony brings with it a punishment up to 7 years in state prison, and a C felony carries with it a punishment of up to 15 years in state prison. Not a lot of people being charged with these things, but you can see, I mean, again, depending on the allegations, the facts, the vindictiveness of the charging officer, any combination thereof, you could see some combination of felony assault charges that are filed against your client. Obviously, all the tools that Brenda just gave us to help figure out what actually happened are invaluable. But when your client is charged, he or she is going to be handed a packet of accusatory instruments that will lay out these charges. When you get these charges, the most important thing in the world to do is read through them, even if, let's assume it's just a normal arraignment, which we're not in normal times, but let's just assume right now. Read through the charges quickly, just to make sure that the basics are there, especially when they charge people in groups. They could get the names, the birth dates, the facts wrong, the day wrong. You always want to make sure that their paperwork is correct. So moving on to arraignment. Now, in today's environment, there is not the standard arraignment that took if it were 2019, for example, and we were doing an arraignment in local court, you'd walk in with your client, you'd be handed a packet of charges, you'd flip through them quickly just to make sure that name, rank, and serial number were all perfectly listed. And you'd step in front of the court and you'd say, "Thank you very much, Your Honor. I acknowledge receipt of the charges. I waive a formal reading, and I enter a not guilty plea on behalf of my client." Now, if you say those things, everybody in the courtroom is going to nod and say, "Hey, that lawyer knows what he or she's talking about," right? They said the right things in front of the judge. You don't want to act like you're, Columbo. And I certainly hope everybody gets, the Columbo reference. But, when you're kind of paging through papers and you're shuffling around and you're acting as if you don't know what's going on, I'm always one, to fake it until I make it. And that is, I say the things that I know I'm supposed to say, and I go from there. Now, in today's environment, mostly everybody is just getting an appearance ticket. That is, the cops are going to charge your client with, let's say, disorderly conduct, resisting arrest, and obstructing governmental administration, a violation, and 2 misdemeanors. Your client will get an appearance ticket. And that appearance ticket will say, your client, John Doe, has to come back on July 7th for arraignment. Now, maybe on July 7th, we're actually all doing stuff in court again at a socially distant, appropriate way. But we are not, as far as I know, and I've again asked around as much as I could, we are not doing arraignments for things like this online. I have done arraignments for things online, mostly kind of serious felonies and things like that. But just for these misdemeanors and things dealing with protests, your clients are going to get an appearance ticket, which again just says come back. Now, when you go back on that date in the future, I want everybody to remember those very simple phrases. Judge, I acknowledge receipt, I waive a formal reading, and I enter a not guilty on behalf of my client. As my old friend Murray Richmond would say, and Murray's an old lawyer out of New York City, in his 80s now, but still goes to work every day of his life. He wanders into court and he says, Judge, I represent my client in the Constitution of the state of New York and the United States of America. So by all means, if you want to go in, and especially in today's environment, you want to send a message and you want to say exactly why you're there and why you're doing this. And I see now 7 pages of people doing this. If you want to go in there and say exactly why you're there, that's great. And look, me and lawyer I care very deeply about, he and I both are known for some theatrics in a courtroom. And so certainly, if you want to throw some fireballs on behalf of your client, to let your client know that you're, doing the thing for her, great. I mean, hey, that's how we get stuff done around here. And I'm certainly not encouraging everybody to be milquetoast when they step in front of a judge. I'm just telling you, as I think this is one of the first things we addressed when we all got online, is, you're here to be their lawyer. And sometimes the lawyer needs to be as objective and as, let's just get the job done and let's get out of here as quickly as possible. So you're at arraignment, you waived a reading, you entered not guilty pleas. The judge will give you a date to come back. And at that point, and again, I think that gets a little more into Mark's topic and how you litigate these things and how you resolve these things. So I won't do that. I don't think we need to step on that too much because, again, bail, we're going to get into the last topic here, bail reform. 6 months ago, the most controversial thing us defense attorneys were dealing with was bail reform, right? Like everybody thought the world was ending then, because people who were charged with resisting arrest were just getting released without bail being set, right? Remember those complaints? But now with bail reform, anybody charged with a misdemeanor, no bail is set. You're released on your own recognizance. The least restrictive means test. The least restrictive means to guarantee the defendant's return to court. And misdemeanors, it's just, hey, you're charged with a misdemeanor, no bail is being set. We'll see you later. So again, for 90 to 95% of the cases that everybody here is going to see, you're not going to have to worry about bail because your client's going to be released and you're going to get a new date to come back. To get into the weeds a little bit about the times in which bail can be set, well, then your client is charged with a felony. Let's say your client is charged with probably something I should have mentioned before, something like criminal mischief as a felony. Now, clearly the criminal mischief statutes were written a long time ago, because if you are accused of committing criminal mischief as a felony, you are being accused of destroying property with a value greater than $250. Now, just about anything nowadays has a value of $250 or more. So you break a couple car windows, you throw a brick through a plate glass window, and I've had this, clients kicking in a cop window when they're being arrested, right? That can be a criminal mischief. I've had clients charged with criminal mischief because their face dented a police car door, right? Like ridiculousness. I've seen it all. But let's say your client is charged with a felony, and for the sake of the instruction here, he or she has had 2 prior felony convictions. Okay, long time ago. Doesn't matter the time period. 20 years ago, they've got 2 drug conviction felonies, long since paid their debts to society, but they're old and they've got 2 priors. Well, based upon that, 2 prior felony convictions and the new felony charge, local court cannot, by law, cannot set bail. Okay? Which means that your client is immediately taken into custody, and bail can only be set by a higher court. Now, up here in upstate New York, it's always called county court. Other parts of the world, it's called Supreme Court, but everybody understands that it's the jurisdiction in which the jurisdiction of the court is those courts that hear felonies. So you would have to go to that superior court and file a formal written bail request. Your client is charged with criminal mischief, which is a nonviolent felony. You go to that superior court, we'll call it county court, and your client, and this actually just happened to me on a different kind of case, non-criminal or nonviolent Berg Third, 2 old felonies. You have to go through the whole song and dance in a higher court just to have the judge say, oh yeah, this is a non-qualifying offense, which is a term under the new bail statute, a non-qualifying offense. You're released on your own recognizance. We'll see it at a court date to be named in the future. So, your client is, again, arrested, has 2 prior felonies, is charged with a new felony, can be as minimal as the criminal mischief, can be as serious as the assault in the 2nd degree or assault on a police officer, a little bit more serious. Then you're suddenly in county court, not that day, but a couple of days later, because you got to get the bail app in, you got to get it scheduled, you got to find a judge, right? You got to go through, especially nowadays, you have to go through this whole song and dance to get it scheduled. And then eventually you're appearing in front of the county court judge, and you are arguing for the least restrictive means to ensure your client's return to court. Happily, I can say that in bail reform that we've seen since January 1st through March when we all shut down, and even through the past couple of months when I've done bail hearings, when I can get a bail hearing, when I've done bail hearings online, the judges still have been very good about either setting no bail, releasing them to the conditions of probation, or finding a very low bail amount that my clients could pay for. So hopefully, even with bail reforms that are, again, being changed or being modified in the next couple of months, we're going to see pretty moderate bail amounts being set. Now, in terms of whether or not at arraignment, and this is maybe one of the last things I want to hit, you want to move, after you've read through the charge, you want to try and make a legal motion to dismiss. By all means, you can, right? Again, maybe this moment calls for a little more theatrics than what I am instructing people to do. But understand that at arraignment, usually one of the only arguments that works for dismissal is what is called a jurisdictional defect. That is, when the charge is jurisdictionally defective, sometimes the judge will hear your oral motion to dismiss. They don't have to be, the law actually kind of requires most motions to dismiss to be in writing. But long time ago, I would say one of the movement's good friends, Tom Keefe. I appeared in front of Tom Keefe on a guy charged with loitering. And I said, it's that arraignment. And I said, Judge, I move to dismiss this loitering charge as jurisdictionally defective. And he said, why? And I said, well, because in a loitering charge, it has to allege that he gathered with other people to loiter. I said, in this individual, he didn't loiter with anybody. They say he was loitering by himself. And Tom Keefe smiled and said, Lee, of all people, your client could loiter by himself because my client was a frequent flyer in local court. However, the judge did grant the motion to dismiss right then and there on the spot, and the young assistant district attorney ran in the back, wrote the loitering charge again, included some names on the bottom and the to wit portion, ran out and handed us the new charge before me and my client could hit the front door of Albany City Court, which is to say that jurisdictional defect can be cured. So don't get too pumped. It is a momentary victory when your client has his or her charges dismissed at arraignment, because 99 times out of 100, they can just be rewritten, refiled, and you're right back there doing the whole thing all over again. Strategically, if you want to do it, how you want to do it, if it makes sense, you got to trust your gut. And as we always say, if you're feeling froggy, then jump, because and if there are any questions, I'm pretty easy to find. I designed my own website, so of course I can only use my last name because I'm not that creative. So just go to kinlan.com and find me. And we're always available. And if you bump into us in the local court, I'm always happy to give advice or point something out if I'm able to do so. But I think that's just about my time, right?
Thank you, Lee.
All
Great.
right, Sarah.
Yeah. And I can vouch for that. If you go to court and you say the things that Lee told you to say, even if you've never been there before, they will treat you like you have. So it was definitely my first time in Albany City Court was representing the movement. The other thing about how you present yourself, another thing that I found helpful from the Poor People's Campaign is to also talk to the movement if there is if it's an organized action in advance as opposed to a spontaneous protest. You have an opportunity to ask the movement, especially if you're representing a whole group of protesters, whether or not they want any of that from their attorney, right? So just another thing to think about is if you're representing a movement or a group of people, they may have ideas about that representation, independent of how you feel about it. So always check in with your clients too in terms of presenting yourself. Great stories though. Mark Mishler is next. from the Law Office of Mark Mishler, and is a mentor of mine in this work and helped me figure out the things to say in criminal court. As an immigration lawyer, sometimes we feel like criminal lawyers, but it's very intimidating to be there with people like Lee and watching them go before you and know all the things to say. And I know lots of you on this call are not criminal defense attorneys as such, but we're here to support that. And I'm just speaking from experience, it's not that scary. So Mark, with that, I'll kick it over to you.
So thank you, Sarah, and good afternoon, everybody. It's really, I think there's 171 people on this call. That is truly wonderful. And I'm so glad everybody is here and participating. So I also want to thank the Legal Project and BALSA and LALSA at the law school and Albany Law School itself, as well as the National Lawyers Guild, for pulling this together in less than a week, which I think is a remarkable accomplishment. And Brenda really, I think, deserves a lot of credit for initiating this and reaching out and pulling this CLE together. So thank you very much. So you know, Crystal started us off with video and her description of her experience as a third-year law student at the rally and the gathering that took place outside of the Albany Police Station last Monday evening. And I really thank Crystal for being there and for being able to share that experience in such a powerful and compelling manner. And Brenda for the really very more professional with PowerPoints and everything, and running down all of criminal procedure, which was fantastic. And of course, Lee, really fantastic presentation about arraignments and those initial proceedings. So I'm going to get into a little bit more of the more overtly political aspect of why we're here and what it means to be representing political defendants at this time. I want to start, I'm going to give a little bit of, I guess, historical background, not a long discussion, a little bit of my feelings and my sense of what the moment is that we're in right now and what that calls upon us as lawyers and others to do at this time. So I want to start by saying that it's almost exactly 40 years ago, in July of 1980, when I was in between my second and third year of law school, that about a mile from where I was living in Boston, a 14-year-old African-American teenager was shot and killed by a Boston police officer. His name was Levi Hart. He was alleged to have been with two other teens, part of a stolen car. There was a police chase. When the car stopped, Levi Hart got out of the car and ran. He was a relatively small 14-year-old, and this relatively large Boston police officer, Officer Bork, chased after him, and the evidence clearly showed that Levi Hart's skull had been crushed by Officer Bork's revolver, and he had been shot and killed by Officer Bork. So that was one of those moments which we've seen so many times when an event catalyzes a community, and it certainly catalyzed Boston at that time. This horrible incident of a child being brutally murdered by a police officer. So I had the opportunity, and this is now directed a little bit towards the law students who are listening. My third year of law school, I found a way to get a professor to agree to sponsor this, and I worked with the lawyers who were representing Levi Hart's family in their civil litigation against the city of Boston and the Boston police. So that was the first time I was involved in litigating police brutality and police misconduct cases. It was really an incredible learning experience, and I think got me going on a track that has been part of my career since then. We really, I think, must all be so tired of case after case. Brenda started us with, I think, centering us with who George Floyd was as a person, who Brianna Taylor was as a person. The list is endless, but it's worth recalling and continuing to recall this list. It goes back, of course, much long before Levi Hart was killed in 1980, and there's been so many cases since then. Even in this area, in the Capital Region, we have Jesse Davis, who was killed by the Albany police in 1984. More recently, we have Edson Thevenin killed by the Troy police several years ago. We have Dante Ivey killed by the Albany police several years ago. We have Eleazar Williams shot and paralyzed by the Albany police a couple of years ago. The list goes on, and there are several features that are common to all of these cases, local and national. One is it's primarily young Black men, not exclusively, but primarily. Secondly, almost never has any police officer in this country been held accountable for killing the civilian. There are a few exceptions, but that's an accurate statement to say almost never. And our local cases certainly bear that out. No police officers were prosecuted for killing Jesse Davis, a mentally ill man who, as it turns out, and was confirmed years later, the worst that he had in his hands when the police claimed that he had charged them and they shot him and killed him was a little toy matchbox truck. No police officers were arrested or charged with the death of Dante Ivey in Albany, a situation where Black man was stopped for no reason, questioned for no reason, surrounded by police officers, and taken into custody for no reason, tased repeatedly, and died. No police officers were charged in the death of Edson Thevenin in Troy. No police officers were charged in the shooting and paralyzing of Eleazar Williams. So when this happens again, and when this is all seared into our minds, not just our local cases, but we all know Eric Garner, we all know Michael Brown, and now we all know George Floyd, and many others, and Brianna Taylor. So when this happens and happens again and keeps happening, and how can anybody have any confidence that the legal system will respond in anything remotely resembling justice? So what we are seeing, I believe that what we're seeing now, I think, in my written materials, I said the past 2 weeks, the world has been shaken in the past 2 weeks. And I think that's true. We've seen changes. We've seen an uprising of people who just can't take this anymore. We have seen some governmental responses that are positive. I know there's a few other people on the call here who work in the New York State Legislature, as I do. This has been a remarkable week in the New York State Legislature. There are bills that have been passed that have addressed police misconduct and police brutality, that some of which have been there for years. People gave them little chance of passage, and now they've passed and will be presumably signed into law by the governor. It's monumental. And so there's been those positive changes. But we've also seen, and my written materials give some illustrations of some of the horrible depths to which some government entities from the municipal, state, or federal government have gone to to address what they apparently view as this uprising that must be curtailed, must be controlled, and must be put down. And I'm not going to review all the examples now. My materials are there, and I hope people look through them. The point is that I really want to make is that we are seeing these two different things happening at the same time. This remarkable and really beautiful coming together of people throughout the country demanding change and expressing no patience anymore with incremental change, no patience with lip service, and demanding that racism and brutality be addressed seriously by our government bodies. And it's truly a wonderful thing to see. And at the same time, we see government entities that are cracking down. So we see the use of force that is extraordinary. And the video Crystal showed us at the beginning showed tear gas being shot at people in the neighborhood in Albany a week and a half ago. I want to emphasize that I've been in Albany almost 40 years. To my knowledge, the Albany police have not used tear gas against anybody in Albany during that almost 40 years that I've lived here. In Albany, on 2 evenings within the past 2 weeks, the Albany police shot rubber bullets at people. Again, I've been here almost 40 years. I've never, ever heard of the Albany police using force like that against anyone. The Albany police have used military-style armored vehicles patrolling through neighborhoods and through crowds. Never seen that in Albany before. And the experience in Albany is not unique. We've seen this in cities throughout the country where police forces are responding to protests and outrage and expressions of grief and anger with shows of force, with lawlessness, and with brutality. You've seen it in New York City night after night. If you've watched the videos from New York City, there are probably 100 videos that show police officers escalating the situation, acting violently towards peaceful protesters, corralling people in so they can't move, and then with their batons out beating people, pepper spraying, tear gassing, using rubber bullets, and so forth. While in New York City, it's not completely new, I would say that the extent of it in the past 2 weeks has been far beyond anything we've seen previously. And of course, we have the federal government escalating the situation, mobilizing or threatening to mobilize the military, using, and I give this example in my materials, in Washington, D.C., there were these federal law enforcement officers with no insignia indicating what agency they represent, with no badges, and who refused to say what agency they represented, but were there in riot gear, intimidating peaceful protesters in Washington. That doesn't sound like we're living in an authoritarian society. I'm not sure what does. What else does secret police forces in riot gear dealing with peaceful protesters mean? It means that we're no longer living in anything that resembles a democracy. And we've also seen, and my materials include this as well, the implementation of emergency orders and curfews. I'm not going to dwell on this. The materials have the 2 curfew orders that were issued in Albany a week and a half ago. And I would just express my opinion that I think generally curfew orders are suspect constitutionally for lots of reasons. Doesn't mean they're inherently unconstitutional, but they raise a lot of constitutional concerns. Strict scrutiny is applied when a court looks at a curfew order. And at the very least, there needs to be proper notice of the order. There needs to be proper notice of what behavior is being prohibited. And there needs to be a factual justification that provides a basis for a government to restrict people's constitutional rights. My opinion, none of those things occurred in Albany, and I believe that those curfew orders were unconstitutional. And it's relevant to our work and our discussion today because if we end up representing somebody who might be arrested and for allegedly violating this curfew, one of these curfew orders, we need to have the tools to challenge these, and we should not assume that just because a government official issued an order that it is legal. So that's a little bit of sort of the background. My materials do a little bit of a somewhat very selective ad hoc timeline of the history of racism and police brutality in our country. The point was really to try to help everyone be on the same page of understanding, where we are, how we got here as a country, and what is at stake here. I also want to, in addition to the materials that I prepared for this, I feel like I'm in good company because the same day that I was finalizing my materials, two scholars who are much smarter and much better writers than I apparently were doing the same thing. And so in the New York Times on Monday and in the New Yorker on Monday, there were two separate articles which I think are just extraordinary, and I think people should look at them. One is by Michelle Alexander, the author of The New Jim Crow, whose article is titled "America, This Is Your Last Chance," or "This Is Your Chance," I'm sorry. And the other in the New Yorker is by Miranda Taylor, professor at Princeton University, whose article is titled "How Do We Change America?" And both articles go through a lot of this history of racism in our system, racism in our legal system, and the lack of accountability and the need for real change at this time. So I encourage people to read those articles. So my topics sort of quickly, because it has to be quick at this point, are to cover a little bit of representing what it's like to represent political activists. And Sarah did a little bit of, so I'm going to say a little bit more. And then I'm going to talk about some specific defenses that are particularly relevant to representing political activists in these kinds of cases. The justification defense, First Amendment defenses, the use of principles of international human rights law, motions to dismiss in furtherance of justice, and what the notes I've just made for myself earlier today have a fifth category, which is every other defense you can think of and that your clients want you to raise. Which leads back to, like, what is it like representing political activists? And there's not one answer to that question, but I think it's it's important to keep in mind that people who either choose to get arrested in a planned civil disobedience situation, or who find themselves arrested, whether planned or not, in a rally or demonstration or march, are individuals who have chosen to take action. And they've chosen to take some kind of action because they are angry, because they deeply believe that something is wrong and that it's necessary for them to take a stand as individuals, that it's necessary for them to join with others to take a stand. And they may have, as Sarah mentioned, ideas that are very different from defendants in regular criminal cases as to what they want to happen, what they expect out of the criminal justice system, and what they want or expect out of a lawyer. So, you may find that there may be clients in these cases who, despite all of the information Brenda shared about your right to remain silent and all that, who may not want to remain silent. And it's a political choice. They may say, I'm not interested in that. This is what I did. This is why I did it. And I want to tell anybody and everybody, the judge, the jury, I want to say what I did and why. I want to be able to explain that. That, of course, is their right. But it's different from what we ordinarily encounter. You may have clients, sometimes in a group situation. Some prosecutors will try to pick people off or separate people. Well, this person has a prior criminal record, so we're going to offer this person a higher disposition of a higher plea bargain than somebody else who doesn't have a prior criminal record. And your clients as a group may say, no, we're not going to do that. Either everybody gets the same deal or everybody's going to fight this out. And we're going to stand united, even if for a particular individual, even if that might cause some, puts them at some risk that they might not otherwise have. And there are also maybe clients who really don't want lawyers to fully function like we think lawyers should function. Number one, people may want to represent themselves because they want to stand for the position that you don't have to be a lawyer in order to speak to justice and address the legal system. There may be clients who don't want you to make what non-lawyers call technical defenses. I had did a trial in Albany City Court some years ago where there are 4 defendants. These were students who've been arrested in a protest about Central America and U.S. involvement in Central America. And the police could identify what 2 of them did, but they actually had no idea what 2 of the defendants did. So when the prosecution rested their case, of course, as a criminal defense lawyer, I moved to dismiss, I moved for a trial or dismissal against those 2 defendants who the prosecution had essentially presented no evidence. And as soon as those words came out of my mouth, those 2 clients, were pissed off at me, like, no, we don't want you to make that motion. We don't want the charge dismissed. If they're not going to be dismissed against everybody, we don't want it dismissed against ourselves. And, these are things that we just have to think about as lawyers that may be different from what we ordinarily experience. Okay. I think that it's in this time, particularly for any lawyer who ends up representing somebody arrested during this time period in some sort of an action that relates to racial justice, it's really important to try to really deeply understand what motivated your client to be at that particular place at that particular time. Maybe the person is a very experienced activist. Maybe it was the first time they were ever at a rally. Maybe they can articulate in a very scholarly way the history of racism and why they were there. Maybe they can't do that, but know it so deeply in their hearts and in their souls that they know that that's why they were there. To have client-centered representation that is meaningful in this context, it is not necessary that we as lawyers agree with everything our clients say or do. I would say it is necessary, it's essential to at least understand or make the best effort you can to understand what motivated your client, what your client is thinking, what your client wants. If your client was outraged, why was your client outraged at what's been happening? And from that, you can then develop a legal strategy. And so the different types of motions to dismiss that are very quickly, I'll go over. Justification, it's an old principle in American and common law that even something that might otherwise be criminal conduct might not be criminal conduct if there was a necessity for the person to undertake the action they did in order to prevent a more serious harm. So one common example, of course, of justification is self-defense. So people have a right to use force in self-defense or in defense of others under certain circumstances, even if that use of force might otherwise be something that would constitute a crime. But in political context, it comes up in a different way. So, like hypothetically, let's say somebody was arrested on Henry Johnson Boulevard at that rally that Chris showed us video of, and charged with, disorderly conduct or charged with obstruction of governmental administration, as examples. May be able to say, this was justified, whatever, even if this person engaged in conduct that might otherwise be considered criminal or let's say trespassing, might otherwise be considered against the law. It was justified and it was necessary because there was a much greater harm, and the person was acting to prevent that greater harm. What's the greater harm? The racist criminal justice system. What's the greater harm? The lack of police accountability. What's the greater harm in the immediate context? That the police were intimidating and bullying peaceful protesters, and that somebody had to take a stand, and that even if it might otherwise constitute an offense, it shouldn't because it was necessary under those circumstances. The materials on the screen should be this sort of table of contents. So there's some materials I prepared just for this program today, but the bulk of the materials are actually materials that were prepared 2.5 years ago that go into much more detail about all of these defenses. There's case law that's described there. There's some examples of pleadings and court decisions relating to justification. Justification is almost never accepted in political cases, but that doesn't mean it shouldn't be raised. At the very least, it can provide an opportunity for your clients to express to the court why they did what they did and why it was essential in their minds for them to do what they did. The next defense area is international human rights law. It's an area that requires a lot more time than 2 minutes. The quick version is simply that we as lawyers in this country are generally not trained and not taught in law school that there is a whole body of law that exists outside of US law, which are international rules of law, some contained in United Nations documents, some contained in other international treaties that are human rights related, and that obligate, for example, governments such as the United States government not to engage in racial discrimination, that obligate the United States government and other governments not to arbitrarily detain people, not to allow the arbitrary and excessive use of force by law enforcement, not to infringe upon the rights of people to voice grievances. These are all principles of international law. It's also a principle of international law that when one's government is acting in a way that violates rights, that we each of us has an obligation under international law to take action. This is the Nuremberg Principles. After World War II, the victors, the Allies, got together and put Nazis on trial, and as well as the leaders of the Japanese imperial military on trial for violations of human rights, and established a set of principles under international law. It is not enough. You can't say, I was just following orders. That's not enough. And I'm sure Lee, and if there's any other veterans listening, know that in fact our armed services are taught this. Doesn't mean they all follow it, but they're taught this. It's part of the military code in the United States. You have not only a right, but an obligation to disobey unlawful orders that violate human rights or that are war crimes. And as individual citizens, we have an obligation to say, enough is enough. We are not going to stand by and let our government engage in violations of rights. We will stand up. And to do that is a defense that can be raised in these cases. Another defense, and Brenda talked some about this First Amendment issues. I take a very broad position on the First Amendment, which is people have a right to do almost anything. I know the case law says there are some limitations. I don't really like those limitations very much, mainly because they're used to cause problems for the movements and for people's movements. But generally speaking, people have a right to gather. People have a right to assemble. People have a right to express their grievances to government bodies. People have a right to speak, and people have a right to engage in symbolic speech. And these are, at the very core of what our democracy means in this country. And I think we as lawyers and activists always need to stand up for the broadest possible interpretation of the First Amendment, because that is what gives us our voice and our basis for action. And in many political cases, the First Amendment can provide a very valid and strong defense. Then there's a statutory defense under New York law, dismissal in furtherance of justice. This is the criminal procedure law provides 10 factors, and it can be a very useful way for lawyers and clients to present to a court who they are, why they did what they did, what the goal was, and to couch that, you find a way to fit those 10 factors, which is not hard to try to do, and present a compelling argument to a court as to why the charges should be dismissed, because it would be an injustice for that prosecution to continue. I mentioned earlier, every other defense you can think of. Lawyers need to be creative, need to be aggressive in defending our clients. I don't accept the definition of that some things are, quote, technical defenses. It seems to me a technical defense means that you are asking the court to apply principles of due process. There's a constitution, you have a due process right not to be prosecuted based on an accusatory instrument that is defective. You have a due process right not to be prosecuted without proper evidence, without probable cause. These are not technical. These go to the very core, again, of what our constitutional system is supposed to be. So I know my time's coming up quickly. I guess I want to also emphasize, I can't imagine that there's any lawyer listening or any law student or anybody else who's ever been to a criminal court who could honestly say that the experience of going to a criminal court in the Albany area, as well as every other place in the United States, is that the racism is palpable from the moment you go in there. It's palpable, certainly, I think, to people of color who feel that very deeply and very immediately. I think for those of us who are white, we ought to pay attention to that reaction that people of color have. I think we ought to think about how, for example, prosecutors talk about our clients, how prosecutors deal with our clients. We ought to think about the ways in which judges are willing to engage with our clients as human beings or not, the respect to which our clients are given or are not given. Particularly in the capital region, the stark racial disparity in regard to who's on the bench, who the prosecutors are, in fact, even for the most part, who the defense lawyers are, who the police officers are, who the deputies are, who the stenographers are. In other words, who everybody is who's part of the system except for the defendants. And that stark disparity is shocking. It should be shocking to us. It should be shocking to us when we have judges who are demeaning to our clients who are people of color. And we should not let it ever not be shocking. And I think that that's, to me, those are, it's something to not ever be lulled into. It's not acceptable to say, well, this is just how it is. We've had judges in this area. I'm going to try to be a little careful here, but I've had experiences with judges in this area, white judges, which is almost every judge, but white judges who it is clear can't even look a person of color defendant in the eye. They just can't do it. I don't know why. I mean, I do know why, racism, but a person appears in front of you as a judge, as a defendant, you as a judge, look down at the paper, you look away, you look at the lawyer, you talk to everybody else. You won't even acknowledge the humanity of the person in front of you. Again, if there's a lawyer on this call who hasn't observed and experienced that many, many times, I can't believe it. I know it happens all the time. So I know my time is up. One more just very quick legalistic thing I want to just mention. If people may have potential for a civil claim arising out of being arrested or the circumstance of their arrest, lawyers need to know that there are certain types of dispositions of criminal cases that interfere with or could interfere with pursuing a civil claim later on. So, for example, an adjournment in contemplation of dismissal, which means the case is adjourned for 6 months and then dismissed. In many situations, that's great. The client's been arrested, the case is going to be dismissed, no record, no conviction of any kind. It's really great. Due to some technicalities in the law, if you agree to an ACOD, you cannot bring certain types of lawsuits claiming that the arrest was and prosecution were invalid. It also applies, by the way, to dismissals in furtherance of justice. There's some court case law that says even getting a dismissal in furtherance of justice bars you from bringing certain types of civil actions later. Just something to keep in mind. If you're representing somebody and something is offered, you need to know whether your client might want to pursue a civil claim later, and you need to advise your client about the potential impact of that. So thank you. I think my time is up. I know these materials it's like 400 pages. My pages, cover about 90 pages, probably too much, but I hope people read it and find it interesting. Mary Armistead put in like 100 or so pages, essentially an entire treatise on the practice of criminal law in New York, which is fantastic. It's an incredible resource. So please make use of those resources. And there is also embedded in there's a series of pages that deal with elements of offenses similar to what Lee covered. Those materials were prepared by Kathy Manley 2.5 years ago. She should be identified on those materials, but she isn't. So thank you all very much. I look forward to any questions. And as the others have said, please feel free to contact me at any time. Thank you.
Thank you, Mark. And before we move on to our next speaker, I want to give our second co-word, although Mark had a good guess that it would be racism. That would have been appropriate, but instead we made it justice, because I hope that everyone on this call is ready to seek justice for Black individuals who have been far too long systemically oppressed in our system. And I just have to point out, Brenda and I were talking earlier that we do completely recognize that most of the speakers on this event are white attorneys. And unfortunately, Chris recently, our law student speaker, Chris recently gave me the statistic that only 3% of attorneys are Black Americans. And so obviously finding diversity to include in the CLE would be very difficult with such limited numbers of Black lawyers in our system. And that is absolutely a result of systemic racism and oppression in our legal systems and our school systems. Et cetera. So I just wanted to note that we are aware of that. We did recognize that. We apologize for it. But I hope that these excellent speakers who have given you so much great information help you to fight for justice for individuals in these systems. So again, our 2 CLE code words are systemic and justice. Thank you.
Thanks, Mary. And thank you, Mark, for always reminding us of our calling in this work. We have a lot of anti-racism work to do as actors in the system. So that'll be our next CLE, how to be an anti-racist lawyer. We'll be hearing from Trevor Hannigan in just a second. There was a request, Lee, I don't know if you're able to come back to us. There was a request for the arraignment advisals to have those repeated again. And maybe I can get Lee to put those in the chat at some point while Trevor's talking, or maybe we'll bring that up again in the Q&A. Since Trevor is our last speaker, I do want to remind you all that you can put questions in the chat. We have different groups of us are monitoring that so that we can structure the Q&A at the end. So please don't be shy. Pop your questions in there, and Trevor will speak to the younger protesters among us. Trevor, you're up next.
Thank you, Professor. Good afternoon, ladies and gentlemen. My name is Trevor Hannigan. Keeping in mind the time, I'll give you a crash course in representing a juvenile in the family court system for someone who's been arrested. So when you're going to represent a juvenile, it requires an analysis of a couple of different factors, including but not limited to their age and the alleged crime that is likely to be filed against the individual. Perhaps many of you are familiar with legislation called Raise the Age. It's been recently enacted, and it was enacted in two separate parts. The first allowed 16 and 17-year-old students or juveniles to be processed in the youth part of the criminal part of the Albany County Court. Now, when a person who is 16 or 17, it was recently added to 18 in October of 2019, is arrested by a police agency, of course, there could be an appearance ticket issued, similar to what my colleagues have spoken about, or this person can be brought directly to the court. Here in Albany County, it would be brought before Judge Rivera, and the individual will be arraigned similar to in a county court or a local criminal court matter. However, when a person is 16 or 17, if it's a misdemeanor that's alleged against this individual, the matter is automatically diverted. It's moved to family court to either be a juvenile delinquency proceeding or a juvenile offender proceeding, unless, of course, it's something like murder. And that, of course, a serious felony would be something that's treated differently. All misdemeanors are going out to the family court to be dealt with, where an attorney would be appointed for that child, either from the public defender's office or an attorney for the child that would try to litigate the misdemeanor disposition for that individual. If the person is accused of a felony, that's when the analysis, regardless of the age, would have to be broken down into separate facts. Is it a serious felony where there's significant physical injury, or was there a display of a weapon, or was there a sex offense? Those classifications of crimes would be considered violent felonies, and they would remain in the youth part for a period of time while the district attorney's office, who would be the agency that's charged with prosecuting these individuals, has to make a determination as to what to do with this case. If it's not one of those particular felonies, the district attorney's office is afforded 30 days to make a motion with respect to whether they want the court's permission to keep the charge in the youth part. Remember, youth part is the criminal part of the family court that's designed to deal with crimes for juveniles. The district attorney's office sometimes makes motions to prevent the removal from the youth part to the family court. If a motion is made within 30 days, the defense counsel, who is typically assigned or retained by the juvenile to represent that person before the court, files a response. Now, these youth part, the proceedings in youth part are much more akin to criminal proceedings, in my experience. I participated in arraignments. I participated in what we call a felony hearing, or like a preliminary hearing. Oftentimes, the preliminary hearing, which is afforded under the criminal law to an individual accused of a felony crime, is dispensed with in the youth part because many individuals are released either on their own recognizance or under probation services, which requires that they check in. It doesn't require that they be on probation. It requires that they maintain an address and a telephone number and they check in regularly. So the need for the hearing would not arise, as opposed to if the individual, if the young person was still in custody. Now, these kids, as I call them, these juveniles, are not incarcerated at the Albany County Correctional Facility with persons who are over the age of 18. There is a facility that is very close to the Albany County Correctional Facility, located off of Shaker Road near the airport, that has been designated as a place to secure juveniles. But if a person who's 16 or 17 and is accused of a violent crime, one of those violent felonies that we discussed initially, is detained, upon turning the age of 18, they are removed from the detention facility and they are placed in the Albany County Jail if they are still being detained pending the resolution of their case. So if the DA wants to prevent the removal of a felony that is not one of the violent felonies pursuant to the statute, they have to show good reason. And the legislation and the legislative history known as Raise the Age essentially guides the courts, because this is relatively new, and at least in many of the decisions I've received, the courts have agreed with the legislative intent that the majority of the cases should be removed to family court. They should not be prosecuting these juvenile individuals as adults any longer. So if the case is removed to family court, out of the youth part, out of the criminal aspect of it, what could happen? Well, juvenile delinquency proceedings are governed by Article 3 of the Family Court Act. An analysis requires the needs of the respondent. So it's not a punitive in the true essence of a criminal court, as the youth part would be, but rather a place where a respondent, where a juvenile would be assessed by a variety of different people, typically their lawyer who would support them, and perhaps the probation department, to see what type of supervision, treatment, or confinement would be appropriate if what's alleged is sustained. Now, the difference between criminal court and family court, the youth part, is the juvenile delinquent in the family court is conducted mostly by people who are participating in the process with a sense of rehabilitation. Well, a person could be confined in a juvenile detention facility for conduct. I would submit that that's less likely now under the Raise the Age legislation, because a case that the DA's office, when it's initially in the youth part, would ask for a punitive punishment like confinement, would seek to keep it in the criminal part rather than allow it to be transferred to the family court. In family court, they typically exclude all violations and offenses that are non-misdemeanor vehicle and traffic law. So if an individual, if a juvenile is accused of disorderly conduct for participating in a protest, it's unlikely that that would go to family court at all. That would likely go directly to criminal court to be disposed of, because it's a violation, it's not a crime, and the statutes don't enable the family court to have jurisdiction over that particularly. The presentment agency, the person who's going to prosecute an individual who is diverted, who is removed from the youth part to the family court, is no longer the district attorney's office here in Albany County. The Albany County Attorney's Office has created an individual whose job it is to present cases to the family court for disposition. And I found that the county attorney's office here in Albany County is very approachable with resolving issues in favor of the respondent, in favor of the juvenile, if the circumstances are advocated for on their behalf. Certainly my colleagues have spoken to you about the types of things that we as defense attorneys do for our clients. If you're going to represent a juvenile who's accused of a felony, my goal would be to try to have it removed from the youth part, the criminal part, immediately to the family court. I've learned, and Mr. Mishler has learned, if you are assigned a client by the court in the youth part and it's diverted, it's removed to the family court, unless you're an attorney for the child, which is a certification separate and apart from being a criminal defense attorney, your engagement in the case will end and a different lawyer is likely to be assigned to that individual in the family court. Once it gets to family court, in my experience and in my practice, I advocate for my clients to receive services if they're needed. And if they're not needed, in my opinion, in conjunction with discussing my client's needs with my client and their parents, then we argue that it should just be directly adjourned in contemplation of dismissal, which allows a juvenile an opportunity to be arrest-free, like Mr. Mishra was just speaking about at the tail end of his. And then the case against that individual would be sealed and dismissed, similar to what would occur in criminal court. Now, something that I've learned in my practice, and I just share this with you, ladies and gentlemen, at the end of this, if a person is ultimately confined as a result of a felony conviction, either as a juvenile offender in family court, that confinement, even though the person is a juvenile offender below the age of 18, it potentially bars that individual from participating in future programs with the New York State Department of Corrections, which I found rather shocking. One of my clients had been determined to be a juvenile offender for a robbery case. He was detained when he was a very young man at 16 years old for a period of time. He ultimately was released. He was doing very well. Unfortunately, he was arrested for a felony crime. He was convicted in Albany County Court. And when he went to state prison, I represented him after his incarceration in state prison to try to modify this injustice, in my opinion. He went to prison for a drug felony. He was advised by the Department of Corrections because of the prior robbery adjudication in family court. He was barred from participating in the SHOCK program or the Willard program or any other program. So just keep that in mind, because it may have consequences down the road when we are advocating for our clients. I thank you, ladies and gentlemen, for your continued attention. It's about 4 o'clock, so I'll cede my time. Thank you.
Did you get through everything, Trevor? Because we can give you a couple more minutes.
I did get through a snapshot of everything.
Well done. Great. So we do have questions that are filling up the chat box. So Mary Armistead, do you want to take it away with our first few questions? I think the first was directed to Brenda.
Well, actually, I got one through a private chat. So one participant asked, I know that Brenda talked about, the freedom to assemble, but then we talked about the criminal charge of unlawful assembly. And so one participant asked, what is the difference between unlawful assembly and the right to assemble?
I think it comes down to that peace aspect, right? So you can assemble as long as it's peaceful. And in some cases, you need to have a permit, right? But if you, if for any reason it's not peaceful, and that's a very subjective term, it could be an unlawful assembly, right? And I don't know, Mark, if you have more to add to that.
I mean, keeping with my position of taking the broadest possible interpretation of First Amendment rights, I generally don't believe it's necessary to get permits. I understand there is a law in the city of Albany. What I can say is that, at least for the past about 15, 20 years, no rally or demonstration or march that I'm aware of that wasn't organized by like a really significant organization, like a large union or something like that, has ever gotten a permit for a rally or march in Albany. And I generally advise groups that, there's no reason to go through that process. You don't need permission from the government to exercise your First Amendment rights. So that's my view. Again, every situation could be different, but that's my position.
Yeah, and I was observing some of the evening protests that occurred in Albany and was watching the live stream in the event that we could be helpful as a group with this in mind. And it does seem that an unlawful assembly is unlawful when the police declare it to be unlawful. So it can be lawful up until they use that loudspeaker. Chris, you may have witnessed that
I was
shift.
going to say, if I could just interject, because one of the experiences when I was thinking about what I might have said earlier that really blew my mind is, to Mark's point, you know, these, we have a a curfew in place. And the first thing that the chief of police said to us, you know, the students on the front lines hearing it was, the protest has to end at 7. We have a curfew in place. So we're going to use any force necessary to enforce the curfew, which led to me in this odd moment bolting to the front of the line and saying, no, they have a lawful right to peacefully assemble. And he had to go inside and check that. So it seems, to Professor Rogerson's point, at any point that they determine that there's unlawful activity is when the police are saying, okay, we get to use force to kind of disband this protest.
All right, thank you everyone for that. The next question was about statutes of limitations for civil actions, but I see that Mark responded to that in the chat, so I'm gonna let that one stand. The next one is, what happens if a police officer violates one of the rules that you discussed, Brenda, such as interrogating without giving a Miranda warning? Is the evidence from that interrogation unusable? What are the consequences for police violating people's rights?
And so I'm going to try to answer this the best as possible. So statements that were acquired, depending on how they were acquired, but if they were unlawfully acquired, they can't be used against you in the court of law, okay? So let's say they didn't give you a Miranda, but they started questioning you, anything that was said can't be used. If for any reason they were spontaneous though, like there's an exception that would take it out of the Miranda area, then those statements can still be used as long as they're part of those exceptions. So no, they won't be able to be used and they can't be used against you in court. With regards to officers that don't follow the protocol and the proper procedures, nothing really happens. And to be honest, unless someone calls them out on it, unless a prosecutor or the public holds them accountable, nothing really happens to those that forego using proper procedures.
Brenda, can I jump in briefly?
Yeah.
Hello again, everybody. I've taken off my tie. Two quick cases I want to bring to everybody's attention, and actually they support what Brenda was saying. I've had, in the past 6 months, 2 cases overturned on appeal based upon statement violations of a defendant's rights when it comes to statements. One is People v. Michael Harris. It was a case out of Schenectady where he talked to the police for about an hour and then said, I'm going to stop talking to you. I want to talk to a lawyer. I shouldn't, I don't want to screw myself, but he used the F word. And initially the trial court said, hey, that kind of equivocating invocation of maybe I should get a lawyer, that can be played. And he was eventually convicted. But the third department sent that back and said, hey, that equivocating answer, you know, you shouldn't play that. So that's number one. And then number two, People v. Chapman, which was decided about 6 weeks ago in the third department, Elijah Day Chapman. My client sat in one of those interrogation rooms in Albany, and for 45 minutes, the Albany police detectives kind of hypothesized on what they thought the case was as my client sat there silently and kind of chuckled at them. Didn't say yes, didn't say no, just either laughed or sat silently. And that statement, I mean, that recording was allowed in court. And, you know, the, again, client was convicted, but that conviction was overturned based upon that you know, really violation, because my client didn't say anything, but the statement should have been precluded from court. So there are some cases, and actually the third department is getting, you know, I don't want to say getting its spine back when it comes to statements and suppression and officer misconduct when it comes to taking these statements. But I certainly think that there's a showmanship that the police are starting to go through when it comes to recorded statements that the law is starting to push back on. So these things exist, and those are 2 victories out of compared to 100 losses I've had. But there is still some good, viable case law being made here.
All right, next question, and I probably should have actually brought this up while we were talking about the First Amendment a few minutes ago. Have you seen arrest based on curfew violation in the past, week and a half? And could you discuss the interplay between curfews and First Amendment rights? Is there a First Amendment defense, and would you pursue this for a client?
I'll take a stab at that. I don't believe in Albany there have been any arrests for curfew violations, to the best of my knowledge. It's in New York City. It was one of the most common charges that people in the past week and a half or 2 weeks have had, violating the curfew. And the answer is absolutely. I mean, I believe every curfew order is constitutionally suspect. It doesn't mean it will be overturned, but it means that courts are really required to engage in what we as lawyers call strict scrutiny, because fundamental constitutional rights are being infringed upon, and the government that has done that, the government body that has done that, needs to have a compelling reason for violating rights. And in the case of a curfew, that there needs to be, as I said earlier, some factual findings to support that. So using the Albany example again, if you look at those Albany curfew orders, it says curfew is going to start at such and such a time and such a date, and then says nothing other than then it goes on and it's like a page and a half that talks about COVID and pandemic. Well, the COVID pandemic has been here for 3 months, and the mayor imposed a curfew on May 30th. And the only factual justification is the COVID pandemic. To me, that just doesn't make any sense. And most likely, any charge for violating that curfew, which would be a crime under the order, any crime charged for violating that should be dismissed.
Thank you. All right, our next question is a 2-part ethics question. So with regard to ethics, for those who have yet to undergo character and fitness investigations, what is the best approach to take if the students or graduates, assuming law students or law graduates, end up being the ones who are arrested? Since all arrests need to be disclosed in your character and fitness application, how can students or graduates minimize the impact on their licensing? And then there was an article that was referenced. And then the second part, just to go ahead and get both of them out there, is for those who are already licensed, what are the ethical obligations that we have in representing protesters that have higher stakes? As Trevor was saying, just thinking about the impact down the road, what should be considered?
I can sort of tackle the first part, and that is for character and fitness, you really need to disclose everything. So hold on to your tickets and to your disposition. That's the most important thing for character and fitness, so that you can show the bar examiners that your disposition was handled and resolved favorably, and make sure if it's a higher charge and you were assigned probation or any follow-up that you complete that and then retain proof of that completion. That's the most important thing for character and fitness. It also raises a question about how you want to participate as a law student, right? And that's, I've actually been talking with law professors across the country saying, like, what's our appropriate mentoring role? And I guess that goes back to what I'm saying at the beginning. Be really intentional when you're attending something in person about what role you're attending in. Because even now we see New York City police targeting National Lawyers Guild observers. So just because you have your lawyer card or your law student card, it doesn't matter when you're there in the streets. So just be mindful of that from the moment that you choose to participate. And remember that there are other non-visible ways to participate, many of which we've discussed today. And it doesn't make you any less a part of the movement. I'll leave the second part to the rest of the group. Maybe we
I
should.
would just say that Rule 1.2 does specifically state that it talks about the allocation of authority between attorney and client. And so pursuant to this rule and any good client-centered practice that Sarah Robertson taught me when I was in her clinic, the client holds the reign of your legal case, right? So as the attorney, your job is to advise them so they can choose the best course of action for their case, but they get to choose the course of action for their case. So doesn't, you know, again, Mark and Sarah both talked about this earlier. We're talking about the choices that activists are making in these cases, and we have to respect those choices. Does anybody else have anything to add to that?
I mean, I agree with that, Mary. The only thing I'll add is, in order to, we also have a role to play in obligations as lawyers, and so yes, respecting the wishes of your client, but our obligation is to make sure our client knows what the risks are and knows what the options are, and you know, has as realistic as possible a notion of, you know, what's at stake, and then and we have a, you know, serious obligation to do that. You know, it's one that most lawyers take seriously. There are we certainly hear of situations where people seem to plead guilty and end up with dispositions that they seem to have had no idea, well, really what they were getting into. And when that happens, that signifies an attorney who's not doing their job properly.
And just because I'm an immigration attorney, make sure that if your client is an immigrant, you advise them of the potential immigration consequences to any criminal action.
I also see Amy Mangione chiming in, who's the admissions director at Albany Law School, to say if you're a current student and you're arrested, that there may be an obligation to update your materials that you submitted to law school to alert the law school of what happened with your case. Particularly since your law school application may be compared with your bar application.
Our last question, although it may be outside the scope, is can anyone discuss brutality, police brutality causes of action?
I'll take this if that's okay.
Yeah.
That is another CLE that lasts about 4 days.
Yeah.
I've done 1983 litigation against most of the police agencies that most of the people know about. They are incredibly complex. They take forever. We resolved one where a guy, after he had laid down on the ground with his hands in the air after a high-speed chase, 5 different police agencies hurt him so badly that they had to amputate his leg. After a week of sitting in a jail, they went in for exploratory surgery because he couldn't feel his toes, and he came out of that surgery missing his leg from the knee down. And factually is very complex. Every police agency pointed at somebody else. You know, look, I'm in business, and I made a decision not to do these anymore because sadly, especially up here in upstate New York, they just don't pay. You know, it's great for the soul, but you got to convince a jury in the Northern District of New York that, you know, police somehow are bad and did the wrong thing in your client, who frankly, you know, might not be the best person on earth, deserves a large chunk of money. And it's really difficult to get through. So I don't want to discourage people from doing it. And there's certainly better people like Kevin Loubrand is always a guy I look up to, and Bud Keach as somebody I love dearly as a lawyer, those guys have certainly mastered how to do it. But they are, from a business perspective, very, very difficult. Maybe the federal litigation or the legislation that's being sponsored by Harris and Booker and all those, that's going to make it a little better because it's going to change the legal standard. But you know, if anybody wants to ask me offline how to do it, you know, I'm happy to talk for a few minutes. But again, that's too long of an answer for the end of a long day. So.
Yeah, so thanks, Lee. I'll just mention a couple of other things that used to be academic but aren't anymore. There's a circuit split that's up for consideration on a petition for cert on state-created danger doctrine, which is particularly applicable in cases where individuals are in police custody and experience harm that they wouldn't have suffered but for the custodial relationship. And there are cases, as Lee mentioned, moving through the courts that may have significant ramifications for chipping away at qualified immunity in the 1983 context. So keep an eye out, because you never know. It only takes a ruling from one judge, and we do have one on state-created danger in the Central District of California, and we have more to come in the immigration context, the immigration detention context. And with circuit splits, those can really lead to watershed moments. So maybe we'll put Lee back in business on 1983, or the justice system may. But with that, thank you everyone for your thoughtful participation, your comments. Thanks to all the panelists. Thanks, Chris, especially, and Brenda. It's so great to have, and Mary, the students involved, students following law school. Trevor is also an alum, 03 alum, and Mark and Lee for your time, because there's so much work to do. And we're so glad to have you in this work with us. Reach out to anyone at any time. There was a suggestion made that maybe we could put together a list of attorneys who are willing to mentor those on this group that have expressed some interest. We'll take that back to the organizers and see if we can get something like that together, just to have people on call, because thankfully there doesn't appear to be an end in sight to this work. Thankfully, and not thankfully. Thankfully, in that we have more people rising up, and we're here to help represent them. So,
and actually, Sarah, I'll just interrupt there with something you mentioned earlier. Brenda Badam and Jessica Prasad are putting together a list of attorneys who would be willing to represent arrested activists. And so when I follow up with when Lisa Ravage follows up with the recording, I will have her send the Brenda and Jessica's emails so that you can sign up for that list if you're interested. And while I'm on it, thank you so much to Lisa Ravage, who really is the true hero here and put everything together.
All right, thanks everybody.
Thank you guys.